So I'm going to talk about immigration and specifically with regard to the new system that's coming in upon us very shortly, and with regard to Brexit as well. And just a quick word initially about the basics of our entry into the UK. And what I'll be focusing on today is on employers and employees rather than any other categories such as students or visitors, because I'm going to be looking at the current and future points-based system and how that affects employers particularly. So as you'll all be aware, the UK currently operates a points-based system that requires UK-based employers to apply for permission for non-EU nationals to work in the UK. And they currently, and many of you will be familiar with this, work here under Tier 2 of that points-based system. And employers, first of all, need to have applied for and obtained a sponsorship licence. And once they are licensed, they can assign or issue a certificate of sponsorship or work permit to enable a non-EU national to come to the UK to work. And that non-EU national then needs to make an entry visa application, usually from their country of origin or their country of residence, to come to the UK to take up their post. And first thing to say is really that many of the current rules, such as I've just described, are going to remain unchanged under the new points-based immigration system. And the Home Office have also said that their aim is to make immigration with the new system much more accessible generally in order to attract more talent to the UK. And the changes that are coming in shortly and at the beginning of next year do to some extent reflect this. So the new system is going to go live on the 1st of December 2020, so just in a few days. And it does represent a major overhaul of sponsored migration. And the most important change is, and there's been a lot written about this, the ending of free movement for EU nationals. The government have said that they want to create a level playing field, and so everybody be treated the same as in EU as well as non-EU nationals. And it will means that the points-based system will be the only option for all non-UK nationals wanting to work in the UK. And the result of that is that it's going to become considerably harder for EU nationals to move to the UK as from the 1st of January 2021. And just a quick word about practicalities and timing. On the 1st of December, just in a few days' time, the new system is going to go live for non-EU nationals. For EU nationals, it will go live from the 1st of January 2021. And everything's going to be done online. The Home Office are doing away with requests for hard copies. Nothing's going to have to be sent in by post. All applications are going to be dealt with via the online portal, the sponsorship management system. Licensed sponsors amongst you will be familiar with this. So the skilled worker route first, and just to remind you that you do need, in order to access the skilled worker route, which is the replacement for Tier 2, you need to be a licensed sponsor, because the heart of the new system is a Remain sponsorship, and you need to then apply for and obtain a certificate of sponsorship in exactly the same way as you do now under Tier 2 via the sponsorship management system. And in order to become a licensed sponsor, the business first needs to demonstrate that it is a legitimate employer in the UK, and they'll need to confirm there's a genuine need for an overseas worker to undertake the work in question. The employer is going to have to confirm that there is a genuine vacancy in the UK that needs to be filled. And before going ahead with the application, the potential skilled worker, or the potential person for whom the certificate of sponsorship is going to apply, has to have a job offer from that licensed employer, certain skill and salary thresholds. And again, because this is a points-based system, in order to qualify to come to the UK as a skilled worker, an applicant needs to have a minimum of 70 points, and they'll be awarded 50 points if first that they have a job offer from a licensed sponsor. That job meets the minimum skill level. And remember that the employer, in exactly the same way as now, has to match the role to a job description set out in the so-called codes of practice that are issued by the Home Office. You can't just make a job description that suits you as an employer. You have to match that to a one set out in the code of practice. Thirdly, and this is really important because it represents a big change, particularly for EU nationals, all applicants are going to have to meet the English language requirement, which is not something that EU nationals have had to think about before. And finally, the post obviously has to have met a minimum salary threshold, much as it does now. And again, those minimum salary thresholds are set out by the Home Office in the codes of practice. And this will again be familiar to all of you, but the visa, the certificate of sponsorship and visa, doesn't allow the holder to work for whoever they choose. It's, therefore much more restrictive for EU nationals than the free movement rights that they currently enjoy. So just a very brief word about the procedure and the way that it works in practice. The applicants have to provide a certificate of sponsorship, which is no less than 3 months old, and they then apply for an entry visa, either, as I say, in the country of their residence or within the UK, if they want to apply for a visa to reflect the change in their circumstances. For example, if they're here as working for another employer or here as a student, for example. And the Home Office have said that they're very keen to reduce the amount of time it takes to bring someone into the UK and to streamline the system. So we'll wait and see if that happens. Just a quick word about intra-company transferees. I mean, these are similarly going to be dealt with under the new system. And it will allow for people who are working for branch or head offices abroad to come to the UK. There'll be a different minimum salary threshold, a higher minimum salary threshold. And most importantly, intra-company transferees will not be subject to the English language requirement. So it's a useful one to use if you want to come into the UK regularly from abroad, but you don't necessarily, as an applicant, want to settle here. Intra-company transfers are useful for that reason. So just a very quick word now about Brexit and UK businesses who employ both EU and non-EU nationals. This will be familiar to most of you, but for EU nationals, any business that employs any EU nationals will need to make sure those who are here now make their applications under the EU settlement scheme for settled or pre-settled status. I've talked a lot about this before, and there's been a big press campaign about it, so it'll be familiar to most of you. This is an application that is made using a smartphone app, known as the EU Exit ID document check. It's a straightforward process and it gives people settled or pre-settled status depending on how long they have been in the UK. And it's EU nationals who are resident here up to the 31st of December 2020 who are going to be eligible and able to make that application. And they've got until the 30th of June 2021 to apply. But those arriving to work, for example, after that, will need to apply under the skilled worker route. And really important point to make, you have to make this application, it's mandatory. And it's mandatory not only for EU nationals, but also for their family members. And it's mandatory even for those who already have permanent resident status issued under the previous regulations. So it's important as employers to ensure that your EU nationals know about this and have made the applications that they need to have made. And they can't lose their settled or pre-settled status unless they leave the UK for a long period of time. I mean, to lose settled status, you have to leave for 5 consecutive years. Only then will you lose your right to return. And for someone with pre-settled status, you'll lose it if you leave the UK for up to 2 years. So that gives you an idea of what EU nationals are obliged to do and what you as employers need to ensure that they do. Can I have the next slide, please? So just to get back to this new system, and I just thought I'd run through a few of the key takeaways. The first and most important one of the new system is that the new system scraps the resident labour market test, the requirement to advertise. It's a really important takeaway for employers because it's going to make the process of obtaining a visa from outside the UK much easier and quicker. Basically, you won't have to advertise as you do now, and it'll mean that you don't have to wait 28 days before applying for your certificate of sponsorship for a new hire. And our advice, nevertheless, is do keep any evidence of advertising as an employer, because you may well be asked for that as proof that you have filled a genuinely vacant position. Another really important change is that the cap on the numbers of certificates of sponsorship has been suspended. So there currently is a limit on the numbers of certificates of sponsorship that can be issued in a year. That's going to be suspended. So meaning that the pool of applicants is going to be much larger than it is now. And the other thing to say is, well, apart from the fact that it's going to be much quicker without the cap, the fact that they've suspended rather than removed it would imply that they could reintroduce it at any time, and they've said that they intend to reduce numbers of migrants coming into the UK to work. So it's possible that the cap could be reintroduced. There are minimum salaries that are applicable under the new skilled worker route. The minimum salary for experienced workers is going to drop from the current level of £30,000 to £26,500. And for intercompany transferees, the minimum salary is £41,500. You won't be successful in getting a certificate of sponsorship for a skilled worker unless you can meet these minimum salaries. But there is a new concept of so-called tradable points, meaning that applicants will be able to trade characteristics such as higher qualifications against a lower salary to get the required number of points. And that's a change. There's a new post-study work route for students that's going to open up from the summer of 2021, and it's going to allow those who are studying in the UK to remain here for 2 years following their graduation and work in an unsponsored, not having to be sponsored. Giving them a lot of freedom. Actually, they can just take up any position they need at a licensed employer and work for 2 years following their graduation. It's still possible to bring your family members as a sponsored skilled migrant under the skilled worker route. You can work on the base, and those people can work on the basis that they are family members of a skilled worker visa holder. I want to emphasise English language. I haven't put this on the list, but it's really important to remember that, because it's not a consideration that EU nationals have had to think about before, and it is going to be from now on. And another major shift from Tier 2 is that there's now no limit on the amount of time a skilled worker can spend in the UK. Under Tier 2, a worker was only able to spend a maximum of 6 years in the UK, but applicants can now be granted permission of a maximum of 5 years at a time, and they can get unlimited extensions. So they'll be eligible in the same way as they are now to apply for indefinite leave to remain or permanent residence, freedom from immigration control, after 5 years in the UK. But their employer has to confirm at that time that they will be employing them. They intend to employ them for the foreseeable future. And similarly, just on indefinite leave, applicants have previously been unable to extend their visa or apply for indefinite leave or to remain unless they met strict absence criteria showing that they'd be continually resident in the UK. And under the new system, a skilled worker visa holder will be able to spend as much time as they want abroad without jeopardising their ability to remain in the UK long term. So that's really very good news and makes it a lot more flexible. So I think the conclusion to draw, just from the things I've mentioned so far, is it's going to be a lot easier for non-EU nationals to work in the UK, but it's going to be much harder and much more expensive for EU nationals who don't have settled or pre-settled status. Cost is the biggest consideration for many employers. So, I mean, obviously, it's positive that the new rules have abandoned the resident labour market test and there's no cap. But, you know, the cost is very substantial. I mean, the minimum cost of just one employee's 5-year visa is likely to amount to just over £6,000 in Home Office fees. And it's likely that that cost could exceed £7,500 when you take into account the immigration skills charge and the immigration health cost surcharge. And that's before you've considered the extra management time and efforts put into the hiring process and the additional costs if the employee is going to be covered by, accompanied by family members, because those costs are going to apply to them as well. So it's a huge financial burden on employers, and it's worth employers thinking about trying to avoid those costs by, for example, employing people who are already in the UK, thinking about unsponsored visa working routes such as the global talent route, or employing people who are here under youth mobility visas or UK ancestry. None of these will impose such excessive cost as those coming or staying under the skilled worker route. And next slide, please. So I just thought I'd quickly focus on a few practical tips and what you need to do as employers to get to grips with the new system. I mean, I've mentioned already, and I just say it again, even though it's not on the slide. Do think about your sponsorship licenses. I mean, if you haven't applied for a sponsorship license, then it's worth doing so now. It's worth reviewing your license if you already have one. The Home Office has written to sponsors to confirm that renewals can be submitted earlier than the normal month ahead of expiry. And it's really important to act as soon as you can on this, because obviously licenses are going to be so much more in demand, because people are going to have to apply, have them in order to apply to employ EU nationals the way they didn't have to now. And the first thing I've put on my list here is the EU settlement scheme. I've already mentioned this, just can't emphasise it enough. Do inform EEA nationals and Swiss employees and their families about their eligibility under the EU settlement scheme for settled or pre-settled status. It's really important that they do that. Because it's going to mean that they can stay indefinitely if they choose to do so, but they need to be here before the 31st of December to have arrived and ideally taken up residence and be able to prove that they're here by the 31st of December in order to take advantage of the EU settlement scheme. They've got until the end of June next year, 2021, to apply. HR policies, really worth making sure that you review your HR processes to ensure compliance standards are met. I mean, the Home Office, as you'll be aware if you're licence holders already, sets very stringent compliance standards for employers of non-UK nationals, and they don't hesitate to revoke employers' sponsorship licenses if they consider that sponsors aren't abiding by the rules. I mean, they'll revoke a license even for minor infringements of the rules. And were an employer to have their license revoked, this would mean that they would need to, any non-UK nationals who are sponsored there would need to stop work, and the sponsor wouldn't be able to sponsor any more workers, and it could be disastrous, therefore, for UK for employers who rely on employing non-UK workers. And remember, there are a significant number of duties you need to comply with. You need to be sure that you can prove that there's a genuine vacancy. If you apply for a certificate of sponsorship, you need to notify the Home Office if an employee's duties change or their salary changes. You need to notify if the company, the sponsored company, the licensed sponsor rather, is the subject of a merger or makes an acquisition. You even need to notify the Home Office if the name or address of a sponsored migrant changes. Make sure you do that, and it's worth upskilling HR teams on sponsor license management and making sure they understand what the requirements of the new system in order to stay ahead of the curve. So just quickly to say, as I said earlier, think about other routes that you could use in order to avoid the skilled worker route, which is expensive and can be complicated, switching into another route, extending people's leave, and making sure that they and yourselves as employers keep abreast of absences. it's not a requirement that a non-UK national records all of their absences, but I always make sure that people do that, particularly if they think that they are going to be applying for British citizenship at any point. I mean, obviously, British citizenship I always mention because it's the only way to avoid or compliance with the immigration rules indefinitely going forward. You can make an application for British citizenship to naturalise after you've held settled status under the EU settlement scheme for 12 months, and you can apply to naturalise after you have held indefinite leave to remain for 12 months. But do watch dual citizenship issues. So I'm making sure that the country of your original nationality do allow you to hold your dual nationality. Just a quick word on timing. Our advice very strongly is act now, don't delay, certainly till the end of the year. Things are changing. You know, the new rules are coming in for non-EU nationals from next week. So it's really important that you as sponsors do understand what your obligations are. Okay, so happy to take questions at the end of the session. Thanks, Jo.